meeting of November 24th. At this time, I would like to convene the Mobile Home Rent Review Commission. And if we could all stand and we'll say the Pledge of Allegiance. So we have received no public comment for this meeting today. And at this time, I'm going to have you all rise again. And if you would raise your right hand, I am going to administer, oh, actually, I am sorry. Sit back down. I have to do the roll call. My fault. I never run these meetings. So I'd also like to mention that Commissioner Allen is attending remotely via teleconference. He's on the line audio. So Commissioner Allen, please state that you're in attendance.
I am here.
Commissioner,
I am here, present.
Thank you. Commissioner Chu? Please use your mic for the audio.
Here.
Commissioner Gomez?
Here.
Commissioner Miller?
Present.
Commissioner Regan?
Present.
Thank you. And if you can all rise, and I'd like to say for the record that Mr. Allen has already taken the oath, but for the rest of you in attendance today, if you would raise your right hand, I will say the full statement, and then you'll just say, I do at the end. I do solemnly affirm that I will support and defend the Constitution of the United States and the Constitution of the State of California against all enemies, foreign and domestic, that I will bear true faith and allegiance to the Constitution of the United States and the Constitution of the State of California, that I take this obligation freely, without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties upon which I'm about to enter.
I do.
Thank you. So the next item on the agenda is the Commission Reorganization. This is where we select a chair and a vice chair. Nominations will be received. Following the nominations, I will read back each nomination if there's multiple, and then the selection will be made by 3 or more affirmative votes. Therefore, at this time, I will open the nominations for the office of chairperson. Do I have a nomination?
I'd like to nominate Brandy Gomez for chairperson.
Are there any other nominations?
I'd like to second that.
Okay, so the nomination is for Brandy Gomez to be the chair. Is that your motion, sir?
That is my motion.
Is there a second? Is with Mr. Regan?
I second that.
All in favor?
Aye.
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 5-0. Okay, I will close at this point the chairperson position. Now I will open the office of the vice chairperson. Do I have a nomination?
I'll nominate Bob Miller as vice chairperson.
Are there any other nominations?
I
Hearing none,
second that.
can I have a motion?
I motion to have Bob Miller be vice chair.
I second.
All those in favor?
Aye.
Aye.
5-0.
Aye.
Thank you. So at this time, if I could have Mr. Miller change places with Mr. Regan. And in the future, if we do have public comment, then Mr. Miller, I will show you the timer. So Chairperson Gomez, I will hand the meeting at this time over to you. And the next item on the agenda is to receive and file the Mobile Home Rent Review Commission minutes of November 2nd, 2020.
Has everyone had a chance to review the minutes? Does anyone want to motion to approve the minutes?
I'd like to make a motion to approve the minutes of the last meeting.
Any second?
I second.
I forgot how to work this. Is this an approval or a receive and file? Yeah, you don't actually need to take action because we don't, other than our chair, none of the other commissioners were on the commission at the time.
Oh,
So we'll just say commission consensus.
Yeah.
I'd like to restate my motion to amend and file.
Thank you.
So the third item on the agenda is the training session. So at this time, Chair, if it's okay if I hand it over to Attorney Grayson?
Good morning.
good morning.
Good morning.
So what I'm going to do this morning is I'm going to go over the ordinance and the rules, outline the procedures that the commission will follow when we have a rent adjustment application that comes before you. There's a lot of information. If you've had a chance to look at the agenda packet and had a chance to look at the PowerPoint, don't get overwhelmed, it's manageable. But if you have any questions while I'm speaking, please don't hesitate to interrupt me. If it's something that we're gonna talk about further on, I'll say that, but otherwise, I want to make sure that you get your questions answered. So what you've been given are the, I know Jennifer has already given you the ordinance and the administrative rules. And then we gave you a handbook which generally describes the ordinance and the way meetings and hearings are conducted for rent adjustment proceedings. And then we've given you the PowerPoint that's up on the screen, and that's what I'm going to go over. So we are here to talk about the mobile home rent stabilization ordinance. As you're aware, it is Chapter 1520 of the Municipal Code, and then there are extensive rules that have been adopted by resolution of the City Council that further implement what is in the ordinance. In addition, the City Council a few years ago adopted rules and procedures for the conduct of hearings, and that was basically to set out timeframes, how long people can speak, to help make the meetings run more smoothly, and those have also been provided to you. And then when we have our hearings, you will be seeing various application forms that park owners or possibly residents will submit to the city. And all of these materials are available on the city's website. So if you'd rather look at them that way, we've given you the links to those sites. The first thing I want to do is put in context the mobile home rent control is actually operating within the umbrella of a couple of other legal parameters. One is the landlord-tenant relationship of mobile home park residents and park owners is governed by what we call the mobile home residency law, and that's in Civil Code Section 798 et sec. I've given you the two ways you can find that online. If you want to look at the provisions, there's not that much that really impacts how we deal with the ordinance. The one issue we will talk about are spaces that are exempt, and in some cases, they're exempt because of statutory provisions in the mobile home residency law. In addition, there are concepts enshrined in the state constitution and the US Constitution that have to do with due process and fair hearings. and I will be talking about that later in this training. Those affect how the city has established the hearings to be conducted, how, again, how much people can speak, that sort of thing. Everything is designed to be consistent with the constitutional provisions. Then we have, as any of you who served on this commission or on other bodies created by a city or the state, we have the Ralph M. Brown Act, which is the open meetings law. All of the commission meetings have to be conducted in compliance with that. And we also have the Public Records Act, materials that you are given, and in some cases, communications that exist between you and the city, as an example. Those are all public records, and so I'll go over that a little bit today. And then we have basically court decisions have established some principles dealing with rent control. And as I'm talking about various issues, to the extent a court has said a city has to do such and such, we will have incorporated that into our procedures. So first, we're going to talk about the ordinance. The ordinance, as I said, is in Chapter 1520 of the Municipal Code. And it basically applies to any mobile home park that was built prior to January 1, 1990. It applies to any space that is held out for rental prior to January 1, 1990. If it's a newly constructed space that didn't exist before that date, by statute, it's exempt from rent control. There are other exemptions that are listed on the slide. And what I will say is generally the commission doesn't have to deal with that issue per se. Normally, the rent administrator will determine in an analysis of an application and the registration how many spaces are subject to the ordinance and how many spaces, which spaces are exempt because they're newly constructed. There may be vacant spaces. There may be park-owned homes, which will not be subject to the ordinance. And then the other exemption are spaces on long-term leases, and I will talk about that for a minute. So Civil Code Section 798.17 has for a long time exempted spaces that were on leases of more than 12 months. And essentially the statute set out certain requirements. There had to be a statement right up front at the beginning of the lease in certain size language that said if you sign this lease, your space will be exempt from any rent control ordinance, et cetera. So that was the law for a long time, and our ordinance recognizes that because it says the ordinance does not apply to any space that is exempt under state law. Well, in 2020, the legislature amended Section 798.17. And I have a typo. To change the exemption to essentially make it terminate. And so what the new language does is it says any lease that was entered into after or between, sorry, I'm discombobbled by the fact I have the wrong section up there. So any space that is entered into in a lease after February 13, 2020, from then on, no new leases or extensions can be entered into that would exempt the space from rent control. The park owner can have a lease. He can have a 10-year lease, but the provisions in the lease that talk about rent will be superseded by the city's rent control ordinance. The other thing that legislation does is it says, as to any other lease that maybe was entered into 5 years ago and has a 10-year term, it's gonna terminate regardless of the end date that was originally in it. It's gonna terminate on February 1, 2025. So, and from February 1, 2025, there are no more statutory exemptions for long-term leases unless the legislature between now and then decides to change the law again. So that will come into play occasionally in the ordinance because when the commission acts on an application, for example, for an M&OI rent adjustment, you're not going to approve a rent adjustment for a space that's exempt from the ordinance because of the lease, but you will take into account income and expenses of the park for all the spaces. So there's analysis that has to be done because of that. So what the ordinance initially did when it was adopted way back in 1991, it rolled rents back to the level that they had been at as of December 31, 1987, and then it provided for a method to increase the rents based on various types of rent adjustments. And so in effect, any increase from the date that the ordinance went into effect until now has to come within the purview of whatever the ordinance will allow. And I will talk about also, there's an annual registration procedure, and I'm going to go into the different types of rent adjustments. And then the other thing I'll mention is that a park owner is required to comply with the ordinance. The ordinance has methods in it for criminal enforcement as well as for civil enforcement if it's determined by the city that a park owner is not in compliance. So, as you all know, you're a member of the commission and you've been appointed. You have a specific term. There are 5 of you, and your job is the most important function that we have, because for certain types of increases, you will be conducting hearings where you will hear presentation of written and oral evidence, and you will make a decision based on that application, staff reports, testimony from the park community and park owner to come up with whether or not to grant a rent adjustment. And it's very important function, and we try to help make it as easy as possible. It's a real exercise in you get to act as judge and jury in effect. And your decision can be appealed to the city council by either side, either the park owner or residents. And the other function that you have is we do conduct a biennial review where staff will present to you any issues that have come up over the prior 2 years, and sometimes comes in with recommendations for you to consider recommending to the council that amendments be made to the ordinance. And when is our next biennial?
Well, we'll be soon now that I have a commission.
Okay, so we're going to talk about the types of rent adjustments, and I'm going to go over terminology. There are, the first one, annual adjustments, are conducted by, determined by the rent administrator in communicating with the park owner and sending out notices. That does not come before you. You will potentially get information on a rent application about whether the park has obtained prior annual adjustments, but those are essentially, and I'm going to talk in more detail, they're percentage increases every year so that a park owner can just get an increase without having to do a lot of paperwork and so forth. And then we have these other types of rent adjustments, capital improvement rent adjustments, emergency capital improvement rent adjustments, and then we have a number of what we call special rent adjustments, which are where you look at things like income and expenses of the park and try to determine if they're entitled to a rent increase. That would be in addition to any annual adjustment or any capital improvement rent adjustment. We also have temporary rent adjustments. Those are a procedure where a park owner has obtained a special rent adjustment from the city and wants to recover the costs of preparing the application, hiring a lawyer or an expert. They're entitled to come in and request an increase that will allow them to get reimbursed over time for the costs incurred in presenting the application. And then lastly, we have a procedure that is a potential rent decrease where the park residents contend that the park owner has either eliminated or reduced an amenity or a service. And I'm gonna talk about all of these. And there is no test at the end of this, so you do not have to memorize anything. So just terminology, we only have a few acronyms in rent control, but I want you to become familiar with them. The first type of increase, or the first set of terms are, as I said, we have special rent adjustments that are maintenance of net operating income rent adjustments, maintenance of net operating income adjustments based on a readjusted base year NOI, and a fair return rent adjustment. And I have no idea why that's duplicated. So a maintenance of net operating income rent adjustment, or we call it MNOI, we will talk about what that means. And that's usually the most common type of increase you're gonna see. Then we have the capital improvement rent adjustments. A capital improvement adjustment is essentially a temporary rent increase that allows a park owner to recover the costs of a improvement in the park. Something is added, a new building, like a clubhouse or a new swimming pool, where they have to put in new streets, something that has a useful life of more than 5 years and otherwise meets the definition of a capital improvement as we've listed it in the ordinance. And those increases are temporary, and I'll talk about what that means. But they're designed to basically encourage a park owner to invest in the park, to keep it maintained, and but also not have the residents hit with a super huge bill all up front. The other type of capital improvement rent adjustment is what we call an emergency capital improvement rent adjustment. And that's to deal with situations if the water system failed suddenly, if an earthquake occurred and the park owner doesn't have insurance for something and has to do an immediate repair where they can't do the type of noticing that they have to do under the capital improvement rent adjustment process, nor is there time to go through and get consent of the residents, which is another element that they may have to comply with under the normal circumstance. So this was something that was adopted later after the ordinance had been in effect for a number of years, because we realized that that was really not yet addressed, but that it could be an issue. The rent decrease procedure, as I said, is if the residents argue that they should get a rent decrease because the park owner has taken away something that the park residents consider to be a service or amenity that their rent was paying for, and they haven't had a reduction in rent, but they no longer have the service. And that can actually also be filed by a park owner, although normally we would expect it to be filed by the park residents. As I said, the temporary rent adjustment is to allow what we call the prevailing park owner who's obtained approval of a special rent adjustment to come in and get a temporary rent increase to get reimbursed for the costs of the application and the hearing. And both that type of increase and a capital improvement rent adjustment are spread out over a period of time, again, to lessen the financial impact on the residents. Yeah, the requirement for the temporary rent adjustment comes from a California Supreme Court case called Galland versus City of Clovis. So you may hear the reference to a Galland adjustment. The court said that not allowing this type of temporary increase can, in certain cases, itself deprive the owner of what we call a fair return. And that's why the court said you have to, in a lot of cases, create some sort of process so that the park owner is not deprived of a return. And so that's why we have this type of increase.
As a staff note, I'd like to make notice that if we do have a case before you as a commission, they typically go a few hours or more. And you'll see experts on the park owner side, on the city side, and sometimes on the resident side. And if at the end of the day, you continue the hearing to another date because you want staff or the park owner to look into something in return, all those costs associated with returning that the park owner has to burden or to pay for is a part of that fee. So you'll see on the staff's perspective, our encouragement to you as a commission, that if we bring an application before you, is that you keep that in mind if you do grant a rent adjustment, that the costs associated with the park owner, with all those experts, will be paid for by the residents of that park.
So now we're getting into the nuts and bolts of terms you're going to hear a lot about. When we talk about maintenance of net operating income rent adjustments or M&OI rent adjustments, our chair has been through one of these hearings and not sure if she got sick of hearing some of these terms, but she can attest to the fact they are very common. So the ordinance uses the increase in the consumer price index over basically from what we call the base year, which is 1987 initially, to the current year, which is generally the 12 months preceding the date of application. And that's one of the methods by which we figure out if there's an increase, how that increase will be calculated. So you will hear references to the base year, or you'll see in paperwork BY, an acronym. And that will mean, as I said, either 1987, which was the original base year, or if a park owner has come in some intervening year and obtained an M&OI rent adjustment, their base year will be reset as the current year that was used in that application. So if they came in 1995 and got an increase, their base year will not be 1987, it will be 1995. The current year, or CY, is generally, as I said, the 12 months immediately preceding the date of when the application is submitted. And as I'll talk about this, what you'll see is you'll see income, in this case gross income, you'll see categories of income that come in the application for the base year and for the current year. And you'll have two sets of data that will become relevant in determining whether they are entitled to an M&OI rent adjustment. So gross income are the park's gross space rents, whatever the park owner was charging for each space over that year period, and any other income that the ordinance allows them to charge. Maybe there's a parking fee, maybe there's a storage unit fee, anything that the residents, you know, like not coin-operated laundry machines because they pay for that themselves, anything that the ordinance recognizes as a category of gross income. We also look at operating expenses, and again, the ordinance lists and describes what are allowable operating costs. And the reason why these two factors are important is because we look at, if you subtract operating expenses from gross income, you get what the ordinance refers to as net operating income, or NOI. And if you think in layperson terms, that's profit, theoretically. So you'll also hear NOI or net operating income. The other thing, and I'm not going to go into a lot of detail about the CPI because you will probably want to kill me. The ordinance as originally adopted it relied on the database of the Consumer Price Index published by the Bureau of Labor Statistics of the Department of Labor for the geographic area that was represented by LA, Riverside, and Orange County. And that was the applicable data source that the city would use to calculate, and park owners and residents would look at to calculate the various types of increases. However, that methodology was modified by the Bureau of Labor Statistics, where they separated out the Riverside, San Bernardino, and Ontario areas into its own database. And that, because of the way the ordinance works, we had to come up with a system where certain annual adjustments use the old one, the LA, Riverside, Orange County. Then in 2018 and 19, we used a new database, which was the LA, Long Beach, and Anaheim. And now, since 2020, for annual adjustments, we're using the Riverside database. And so I've given you, if you're a glutton for punishment and want to look at these, I've given you links how you can actually go on the Bureau of Labor Statistics website to look at these. So a couple more factors we have to look at. We look at the base year Consumer Price Index. The ordinance specifies it as 114.8, that's in the rules. Or if the park has obtained an increase after the base year, then we look at whatever the CPI was that was used, the most recent adjustment. And then we look at current year CPI. And I'm going to give you examples. If you've looked at the PowerPoint, you've seen an example. We're essentially allowing an increase under the MNOI adjustment based on the 80% of the increase in the from the base year CPI to the current year CPI. And these are directly from the Bureau of Labor Statistics website. What makes it a little challenging is the original one, the Bureau's information was always a month behind at least. So whatever was posted on the website as of whatever date the city needed to take action, that would be the information that would be incorporated into the analysis. What's made it a little more challenging is the new one for this geographic area is only issued every 2 months. And so how behind are we generally? Just still 1 month or?
A month to almost 2 months, depending.
Okay, yeah, so this was taken off the website last week, so you can see that's what was available as of close to the end of November. Just a little bit on registration. In order to track the information about spaces in the park, to make sure that the city understands which spaces are exempt, which spaces are subject to the ordinance. If a resident were to come in and say, I'm paying this amount of money, but my neighbor's paying this amount of money, you know, is this allowed by the ordinance, et cetera, the city created a registration process. So when the ordinance was initially adopted, they had to initially register. That set sort of the baseline. And then every year they have to register, and the registration form basically asks them to identify all the month-to-month spaces that are those subject to the ordinance, any spaces subject to long-term leases, any vacant spaces. They also have to list if services are included in the amount of rent charged, like the water costs, they're not separately billed for it. Then they need to list that in a space on the form. If they pay certain services separately, such as directly to the electric company or the gas company, those have to be listed as well. And there's an annual registration fee that the city council determines every year, and that is split between the residents and the park owners. And it's not part of whatever is rent, quote unquote, under the ordinance. So I mentioned annual adjustments. In order to enable park owners, because we are regulating how much and how often they can raise rents, the city created a very simple process for the park owners to increase the rents once every 12 months by the lesser of either the 80% of the increase in CPI over the prior 12 months or by 4% of current space rent. And I don't know, Jennifer, do you want to say anything about the annual adjustment since you do that?
Yeah, every year what we do is we take the costs associated with administering the rent control department within the city, and then any costs associated with a special rent adjustment application. And then the formula is built on a 3-year rolling average, of which we bring to the council to review and approve, which is done typically in September. We notify the park owners and the residents, and then that fee kicks in January 1st of each year.
So on the annual adjustment, this slide, I made up all these numbers. Hopefully did not make any math errors. One thing I discovered with rent control is I have to do my calculations about 5 times to make sure I didn't do any math errors, even when I'm using a calculator, which is a little bit scary. Anyways, so the slide, I have to look at my binder because my glasses aren't working to make that clear. So if you see me looking down a lot, that's why. I apologize. So what the city does is it calculates the change in CPI, and that's the column on the left. You see current CPI minus prior CPI gives us what we call a point change. And essentially, we just take whatever numerical amount is listed in the CPI chart for whatever month we're in. In this case, it would normally be November. And we subtract the prior CPI to come up with the remainder, and then we calculate what percent of an increase that is. And that is how we get in the little chart to 1.97%. And that's 100% of the increase in CPI on that calculation. We take 80% of that, and that is the amount by which we compare what increase would result to the resident with using the 1.58% versus what would be 4% of their space rent. Whichever is less, that's their annual adjustment. And so the chart, the little chart on the right is a little example if we were using numbers. In this case, the rent would go up by $9.48, and I showed you how the rent administrator would calculate that. And we don't usually have issues with annual adjustments. And those do not come before you. So this is just a slide to give you a sense of how the annual adjustments have changed over time. As you can see, back in 2015, when there was nothing happening with the CPI, park owners got a 0.58% increase, which was almost nothing. But we're up to 1.54%. That increase will go into effect if they've given their notice, their 90-day notice under state law. The soonest it can go into effect is January 1 of 2022. You want to say anything?
Yeah, I think one of the things that we've looked at as a commission and as a city council over the past several years is that whole question, right? In the sense of if the park owner is getting a very small annual adjustment every year because of the cap of 80% of CPI, that starts to trigger those special rent adjustment applications. And if they're getting that small incremental change that is not even covering their cost of doing business, you start to see a spread going this way. So when those special rent increases come in before the commission, they're quite substantial. And so in the biennial review process, I think for the last 4 or 5 times, which has covered more than probably 15 years, Amy and I have presented to the commission for consideration looking at making the adjustment to 100% of CPI. So when we come back this year, we'll give it as an option for you to consider. Ultimately, your recommendations then go to our council, the city council, and then the council will make a ruling on what amendments they would like to be made to both the resolution and the ordinance.
This is just a little flow chart. I didn't know if you were visual. I'm visual, so I like to see things like that. That's just to give you a sense of how it works. There are also specific timeframes by which the park owner submits their application. The administrator, I'm calling you a rent adjuster, has to act on the application, make sure it's complete, make sure that she doesn't need any additional information, and then issues a decision which she provides notice to both the park owner and the residents. And there is a protest procedure, but it just it stays internal. It does not come before you. Now we're going to talk about capital improvements. So the ordinance definition of a capital improvement is on the slide, and it means the installation of new improvements or facilities and or the replacement or reconstruction of existing improvements and facilities which consist of more than ordinary maintenance or repairs, have a useful life of at least 5 years, and also meet the requirements of the ordinance. And those requirements relate to resident vote and things like that, and I will talk about that. So just as an example, and in fact, I'll go to the next slide. The rules provide examples of what are the types of expenditures that may qualify as a capital improvement. Painting would not, but when you're painting the interior of walls, if part of what you're painting is the outside of a building that's going to help extend the life of it, that could be a capital improvement. Certain types of paving of streets. Slurry seal is not a capital improvement, but if you dig up the entire, I'm not going to get the terms right, but if you dig out the asphalt and redo it, that would most likely be a capital improvement. So we've tried to provide examples in the rules. There's a chart in section 5.0004. And we also have provided what are, I'll say, the recommended amortization periods. Park owners can propose an alternative amortization period, but the reason for that has to be documented so that we know that again, we're trying to not create a huge financial burden on the residents. So the capital improvement rent adjustment process requires for what, like, I want to redo the streets in my park. There's no immediate need for it, but I don't like how they look, and I want to redo them. So as a park owner, I have to call a resident meeting at which I have to explain why I want to do the improvement and how much it's going to cost, because they want to know, the residents want to know what the cost will be, what the period of time is that I'm proposing I be able to charge that, and then I have to have an election. And if it's not an improvement for health and safety reasons, I have to get at least 51% consent from the regulated spaces in the park. So if you've got a 100-space park and they're all rent control spaces, you need 51 spaces to say yes. If only a portion of those spaces are under rent control, then it's 51% of the regulated spaces. Park owner can charge under an exempt lease, they can charge what they charge under their lease, but for purposes of our ordinance, we do give the residents the ability to say yes or no when it's not a health and safety issue. So as I mentioned, it is temporary. It only will be on the rent statement for the life of the improvement, and it will have an expiration date. And then the rent administrator will get that application. The rent administrator will make the decision and send out notice to the residents and the park owner. If either side does not like the result, they have the right of appeal to this commission. Now, in the case of an improvement that the park owner contends is for health and safety, if they can, like, let's say they say the streets are dangerous. There have been 5 accidents in the park, all according to the park owner because of the condition of the streets. They can go ahead and do the improvement without going through the resident meeting and the election. But if they can't establish to the satisfaction of the rent administrator or to you as the commission on appeal that it was necessary for health and safety, then they're going to lose the ability to pass that cost on to the residents. And there have been some of those that have come to the city, and there have been some disagreements about whether something was to protect the public.
Yeah, a lot of the cases that we've had on streets are related to the streets are just decaying and starting to crumble. In a lot of the parks, when they were designed, a lot of the infrastructure for the park is underneath the streets. And so even though they didn't get 51% of the approval of the residents, because of the condition of their streets, we did approve it via health and safety standards, and we typically then get the city engineer involved and they take a look at it in addition.
So when it comes before you, there will have been notices sent out by the rent administrator advising the residents and the park owner, there's going to be a hearing on this date and this time. Normally, the date is coordinated so that everybody's available who needs to be at the hearing. That would include you as the commissioners, staff, park owner, and whoever they want to be at the hearing, and the park residents. Typically, they pick a representative, and so it's coordinated so that everybody who needs to be will be at that meeting. At the meeting, the hearing, you're going to conduct an evidentiary hearing. It's kind of like a little mini trial, but not as formal. You're going to get a staff report with the application, all the supporting documentation that the park owner submitted. You'll get the rent administrator's decision. If the residents submitted anything in opposition, you will get their opposition. And then you'll get the decision from the rent administrator and the appeal. So whichever side appealed, it has to be in writing, and you'll see the reasons why they contend the rent administrator didn't make the correct decision. And the additional information that you will have is you will have sworn testimony. So The clerk will swear in witnesses who will then be able to come and testify in front of you. You know, they say they put in the new paving, but it's the same pavement. I'm there every day and nobody came in and did any paving. I mean, that's not normally what happens, but that's, you know, it gives everybody the chance to come in and speak to the proposed increase. And then you're gonna issue a decision. In these hearings, I typically sit up there on the left, and Jennifer is here, and if she has, say, the city engineer or somebody else, an attorney who will advise her as the staff position, I don't advise staff on these increases. I advise you. And you'll issue your decision in writing. Typically, the staff report will have a proposed resolution to deny or the appeal or to grant the appeal, you know, depending on the circumstances. And then that decision will be sent out to everybody. And then if the residents or the park owner don't like it, they can appeal to the council. So your decision, if it's appealed, will not be the final decision. If it's not appealed or it's appealed too late, your decision will be the final decision.
Just to add to that too, because of the setting, we typically also have a court reporter here, and they'll do verbatim transcripts of the proceeding. If it does get appealed to council, then the council will get that transcript, but they're limited to the documents that you've received and the questions that you've asked. So it's very important that when you receive the packet from staff, that you do go through it, you read it, you formulate the questions that you have, because that helps overall with the findings that then Amy has to put in the resolution. You can't just say as a commission, it's not granted because, or it's just not granted. She has to state in that resolution the purpose for whether you're approving or denying it.
Right. And if you've ever heard the phrase a de novo hearing, when it goes to council, it is not a de novo hearing. That means new, okay? So they get the record that you created. They get the staff report, the position of each side, they get any expert reports, they get the transcript, and they get the decision that you've issued. They don't take new testimony. It's essentially an opportunity for each side to make an argument to the council why the decision should be modified. So we wanted to help you in terms of when you get one of these applications, you know, I think the first question would probably be, what is it I have to decide? And so up on the slide is we've listed what are the issues that as a commission you need to make the determination under the ordinance whether to allow the increase. So first one, did they establish it's a capital improvement? If it's not a capital improvement, everything else goes away, and the answer is request denied. So part of your decision will be to state, yes, it is a capital improvement and why, or no, it's not and why. You also will look at, did the park owner have the resident meeting and obtain 51% consent from the regulated spaces? Or if they didn't, is it because it was correctly determined to be an improvement needed for health and safety? So those issues and your determination on them will be in the resolution.
In addition, you'll have my decision, so you can look at actually how I ruled whether the capital improvement was approved or denied. You'll have the basis for my approval or denial.
And then assuming that you decide it is a capital improvement, they conducted the resident meeting, got their 51% consent, or alternatively, they didn't need that because it was an emergency, then the question becomes, okay, what's the rent adjustment, the increase that they're gonna be allowed? And so what we're gonna look at is What was the cost of the improvement, and was it reasonable and documented? What is the useful life that they want to spread the increase over time? Are they saying 5 years, 10 years? Whatever it is that they contend this increase should be allowed to be charged. And also there will be a financing cost, either the actual financing that they incurred or the ordinance and rules allow an amount to be imputed into that. And so you'll get a proposed resolution that will list a determination on each of those issues. And it's the park owner's responsibility to present sufficient evidence, we call it substantial evidence, to support that they should get this increase. And all this is going to be in a written resolution, and you will essentially state in that we grant the increase in the amount of $5 a month for 5 years, including 3% interest, and attached is our list of all the spaces in the park showing what that increase will be. Or we're denying the increase, the adjustment, and here are the reasons why. And you will list, I'm not going to repeat it, you will list all those findings to explain the basis of your decision. And one of the things I will talk about in more detail later is when courts are asked to evaluate what a hearing body like you have decided, they want the roadmap, okay? They want to know, you started here, you ended up here, how did you get there? Not just, don't tell me what you decided, tell me how you got there. Because they will go back and look, subject to the scope of review, they will go back to see if substantial evidence was presented and if the findings support what the decision was. And as I said, if people are dissatisfied, they can appeal to council. Council will get the whole deal, everything, and look at whether they agree or disagree that the increase was appropriate. I've given you the definition of substantial evidence that comes from the rules. This is out of court cases. Substantial evidence is not like beyond a reasonable doubt, okay? That's another type of proof in court hearings, but this is a far easier burden that the park owner has to bear. And so what it is evidence that is relevant, credible, and reliable and provides enough information together with the reasonable inferences from that information to support a conclusion, even though other conclusions might also be reached. So we can have conflicting opinions about something. Is it a capital improvement? You might get an expert opinion it is, and you might get someone else who's an expert saying it's not. The fact there's two different opinions doesn't mean there isn't substantial evidence to support going one way or the other. The limitation is if the evidence is just hearsay. Well, I heard they didn't do such and such. That's hearsay evidence. You can't base your decision just on hearsay evidence. I put in this slide on the timeline because it's important for you to understand that the commission has to act in a reasonably expeditious way based on court cases. And so what we did is we looked at, when the ordinance and rules were originally adopted, we looked at court decisions looking at what timing was deemed to be burdensome for the park owner, because they can't charge an increase till it's approved. So we figured out, okay, maybe 75 days from when you apply with a complete application, courts have said that's a reasonable time frame. So then we backtracked. We went backwards, okay, they have to do this, they have to do this, they have to do this. The commission has to do this, and we built that into a timeline, and that's what you see up on that slide. So when they file their application, the rent administrator has to look at it and determine within 30 days, is the application complete? And that basically means, is everything that the ordinance says they have to submit there without looking at the merits of it, but is it there so that in theory, I should be able to evaluate it and make a decision? If not, the rent administrator issues an incomplete letter and says you're missing the documents showing the cost, as an example. And they then have to submit that missing documentation in order for the application to move forward. If the application is complete, the rent administrator sends out the notice saying the application's complete. Residents, you have 20 days, to submit opposition or a response. And once that time frame expires, then we will set the hearing date, and then the rent administrator will work with everybody involved to come up with an acceptable hearing date within the time frame of the ordinance. Once you issue your decision, they have to appeal. Anybody who wants to appeal has to file within 10 days. And if they don't meet that time deadline, then your decision is final. If they do appeal timely, then the council has its own set of timeframes that they have to meet.
I think that if we do have a case, that's typically you're going to get a very quick phone call from Kim Everts in my office to get you guys scheduled, and we will be pushing for a date sooner rather than later. And it's very vital that you're all in attendance for that day. We'll try to be as expeditious as possible in terms of getting you through that hearing, but I cannot control sometimes the length of a hearing. So to have you maybe tell us, well, I can be there for 3 hours and I have to go, that we cannot do that, because that would require us pulling all those experts back, which is then again potentially an increase to the residents in the park. So do your best to clear your calendars as much as possible, and it's our hope that we don't see very many of these at all.
The hearings can take anywhere from 2 hours to over a
10.
couple of days. Yeah. So it's kind of the nature of whatever the particular application is. And some of them go really fast and, don't take a lot of time.
It is our goal, though, as staff, to have them completed in the same day, and there's reasons said for that. A lot of people do fly in for the hearings on the expert levels, so we will try to get the hearing started in the morning. We'll break for lunch. You'll break together because we have Brown Act issues, but the goal is to get that hearing done that day, and I can't stress it enough. And we do have a policy in terms of the length of time that you allow an expert to speak, and we try to be pretty succinct on that in terms of limiting that, because I'm sorry, Amy, but attorneys like to talk, and they like to get not sometimes what's relevant to the case. Sometimes they want to talk planning for a court review. So it's up to the commission and Brandy and then Vice Chair Miller to ensure that we run a very quick, efficient meeting, because everything that they're really talking about anyway is within the packet that you'd be provided. So the more efficient you run the commission, the better off everybody in the room is, and it doesn't give that attorney a showboat opportunity, is what I typically refer to it as. Correct?
Mm-hmm.
Okay, got her on record. Thank you.
There are experts who do talk too much, just
That too.
and residents and park owners. Just kidding. Okay, so this slide, we just made up this little example again to make it very simple to show you how the actual calculation would work. So in this slide, there's 30 spaces. The amortization period of the improvement is 10 years, and the cost, including financing over that useful life, is $10,000. And essentially, you take that cost, divide it by the useful life, divide it by 12 months and divide it by the number of spaces, and you come up with the increase. Capital improvements can range from something very small like this, which, you know, I made it up, but $2.78, or it can be pretty significant. And so generally in the capital improvement hearings, the arguments focus on, is it really a capital improvement? If they didn't get consent of the residents, was it necessary for health and safety? And also there will be arguments about whether the cost is really what it should have been, and you'll get evidence potentially on any number of issues like that. Anybody have any questions so far?
Do we save our questions for the end?
Nope, you can ask anytime.
Is it okay if I save them for the end?
Sure.
Because I had three, but different segments that you talked about. Okay, thanks.
Okay,
I have a quick question.
okay.
So are we ever able to go on a field trip and go actually look at these parks and what their improvements are?
You can do that. When I'm going to talk about due process and fair hearings, generally you should make your decision only based on what you hear or see at the meeting. But if you want to go and look at the park, you want to look at the improvements, or depending on if it's a special rent adjustment and there's an issue about the park owner didn't do maintenance as often as they should, something like that, and you want to go look at the condition of the park. You can do that. We request that you state at the beginning of the hearing that you did that, so that people know. If you say, I went and looked at the condition of the park and a certain type of application, we look at parks if they're comparable. So if you go out and look at the different parks and say, well, I went out to both parks and I don't think they're comparable and here's why. You know, we want that disclosed on the record, and it's important that you disclose it on the record.
In terms of a capital improvement, like I said, typically what we've seen in the last several years since I've been doing this since 2004 is it typically comes in as a street repair. And you can drive through the park if it comes to you, but we typically ask that the commissioners, no different than staff, I typically call ahead to the on-site manager because it is private property. It's a private park. So I let them know that I'll be coming through, reviewing, taking photos, and doing that. You as a commissioner, you'll want to reach out to that park owner. If you receive an application, you can go take a look. But I would advise you no different than when I go into a park, I don't engage in conversations with the residents or the on-site manager unless I need access to the different sections within the property. So you want to go. The goal of our commission is you need to stay neutral. And so you're there is just so that you can have you can go out and see the condition of the streets within the park. And then that way, when the application comes before you, then you have a right to talk to that park owner or their experts on how did it, tell me about your maintenance in this park. Then you're kind of vested now. You kind of have an outlook on what it looks like. But like Amy says, at the top of that hearing, you will want to disclose if you've been into the park.
Yeah, let me just follow up with one thing Jennifer said. I would caution you very strongly against talking directly with residents or park owners. That's where we get into issues about fair hearing. If you have questions that you're gonna wanna ask anybody who testifies, save them for doing it in the hearing. But I'm sorry, I interrupted you.
Oh, can we go as an individual or have to go in a group?
Well, I would say if you're going to go, I would recommend you go as an individual, because if you go and there's 3 of you, that's a quorum, and that's considered a meeting. So and that creates a whole Brown Act issue. So yeah, it would be better to just go by yourself.
I just wanted to add something just for the commission, the commissioners, that I had received some correspondence in the mail during our first one of the applications that I sat in for. So you have to be really careful if somebody mails something to you. I had opened an envelope and it said, "Dear Commissioner," and I closed it and it went in the trash. So you have to make sure that not to read anything outside of what they're giving you here. You have to, it has to be available for everybody. So all the public needs to have all the materials that we're having. So if something's sent to your home, because our home address is our public record, so that's how they were able to send, mail to me. So you just have to be really careful if you receive outside correspondence from somebody in a mobile home park that wants to kind of explain their side, or a park owner. Just make sure that it's anything that you're receiving, it's part of the public record and not something just individual to you.
If you do receive something and it pertains to like an application that's gonna come before you, you can submit it to my department. And what we'll do is we'll stamp, most likely I'll have received it also, but for due diligence, you can turn it into my department, we'll stamp it in, and we'll include it as part of the packet that's presented to you, so you everybody in the process has access to that document. Whatever's sent to you is a public record, now that you're on the commission.
You're getting ahead.
No, just so that you understand if, based on your point.
Yes, that's right. Okay. We're going to talk briefly about emergency capital improvements. As I said earlier, this is a process to let a park owner go in and fix the water system because a truck rolled down the hill and crashed into it. Certain things can't wait to go through that resident meeting and ballot election process. And so there are certain timing requirements. The park owner has to do the work within a certain time frame and then has to apply for the approval within a certain time frame. That's all designed to make sure they're just not trying to use this process as a way to get around the resident vote. So I don't, at this point, I'm not going to go into any more of that. We have had, I think we've had something. No, maybe not. We have had people claim they didn't need the vote because it was necessary for health and safety, but I think Jennifer's right. We haven't had anybody come in with this method yet, which is a good thing. And this is just examples of what the park owner has to demonstrate. I'm not going to go into this because I will make your eyes roll. Okay. Now we're going to talk about the special adjustments, which are also pretty typical for what you will get. A special rent adjustment is designed to allow a park owner to show that even though they got the annual adjustment, it's not enough to enable them to pay for their expenses and earn some profit. And basically the courts have told us that park owners in a rent control environment are allowed or entitled to a fair return. What they haven't really defined for us very clearly is, what does that mean? And so what I put up on the slide is language from various court cases that says a fair return is characterized as sufficiently high to encourage and reward efficient management, discourage the flight of capital, maintain adequate services, and enable operators to maintain and support their credit status. However, the amount of rent should not defeat the purposes of rent control to prevent excessive rent increases. So what the courts are telling us is, on the one hand, we have rent control because residents have difficulty moving their homes out of parks. They're entitled not to be charged excessive rent increases in this environment where they have no bargaining power or very little. On the other hand, we want park owners to maintain their parks. We want park owners to invest in parks. We want park owners to be able to recover the cost of expenses and have a return on that. And that's the process. It's this kind of nebulous process that the courts have given us. And everything that staff does, that I do as far as advising you, the park owners representative will be making arguments about when these increases are warranted. We're all going to be talking about, is it needed to give the park owner a fair return? So
Just keep in mind too, park owners, it's a business. It's not a county or state affordable, it is a form of affordable housing, but it's not a state-funded system. It's a private business.
and the residents obviously are going to be arguing park owners earning enough money, this violates that idea that I'm going to pay excessive rent, et cetera. So just to remember, these types of increases are not automatic. You're not just filling out a form and checking off boxes. You have discretion on certain issues, and all of that goes into your ultimate determination. Park owner has to support their request with documentation, sometimes expert testimony. Residents have the right to submit opposition or a response. If they are challenging something that we would say needs expert testimony, they have to come in with an expert. If an issue arises, whether certain types of management expenses are reasonable, there needs to be testimony from both sides, whether that is or isn't.
When these cases come before you also, with these kind of rent adjustments, they're going to be listing the application, the park owner, they're going to be listing parks in Yucaipa that they feel are comparable and that their rents are X and ours are way down here. We need to be equal to them. The city, we hire an appraiser also, the city staff, and they may come up with a different listing of parks. And then the residents may also have an appraiser that has a listing of parks. Then you're going to probably have residents come up and say, all these parks are awful, we disagree, whatever. But at the end of the day, you as a commission have a right to pick the expert you agree with most. It may be the park owner's expert, it may be the staff's expert, or it could be the resident's expert if they have it. But they have to be deemed an expert. You can't take it from someone who comes up to the mic as a member of the public that is not a certified appraiser that gives you their input, or you yourself have gone out on your own and decided what park you feel. That's not an expert opinion. You do have a right to pick between the three experts that are certified appraisers. You don't have a right to go off on your own if you're not considered deemed an expert. Does that make sense? In addition, Ben, that would be when you get those applications and they list out the parks, as a commission, you are encouraged to go through those parks so that you can have a better idea what ones you feel, yeah, I think they're on the mark there, or I think they're way off the mark there. And so typically that expert, that appraiser, they're going to come in with higher parks and lower. Our guy kind of goes through the middle. He looks at some high, he looks at low, and he takes an average. So that just gives you a better representation. And typically we throw out, I think, 7 or 8 parks. And so that's a lot of parks to go through, but at least then you have a better idea of, okay, Park X is the one applying and they're comparing it to these 8 other parks. You might be going through and you're like, I feel like all of them are way above or some of them are way below, right? Because it makes sense, because at the end of the day, if they're trying to get to a number, depending on who's the one trying for you to pick the parks, it makes that bottom line different depending on the parks that are chosen.
So the hearing process for these kinds of increases are the same as for the capital improvement that I talked about. There are, again, with these kinds of increases, we have time limits on the rent administrator's obligation to review the application to determine if it's complete. If not, there's a process, the park owner submits additional information. That pre-hearing process sometimes gets dragged out because of not getting all the information, the documentation that needs to be submitted. But again, the city works as much as possible to stay within the parameters of time limits that the courts have said are reasonable. So I'm going to talk about the maintenance of net operating income rent adjustment formula or methodology. This is like the heart of the ordinance. Conceptually, what it essentially says is we assume or presume that the net operating income that the park owner was earning in the base year, which is 1987, was providing that park owner with a reasonable return. So if they had profit of $150,000 in 1987, the ordinance presumes that that was a fair return. And then the ordinance also presumes if we allow that profit to increase by a percentage of the CPI up to the current time, that will also give them a fair return currently. Park owners who apply for this kind of increase, they want to defeat that presumption. Their argument is, well, yes, I got this amount of profit in the base year, I'm getting this amount of profit now, but I'm not getting a fair return because it's too low. And here are all the reasons why it's too low. So we're not looking in this context, we don't look at individual space rents. We look at the park's income and expense as a whole. What's the net operating income based on this indexing using CPI? And do we need to let them increase more, or are they getting a fair return already so they don't get an increase?
Just a small little, so 1987, we didn't have rent control in the city. We had the 42 mobile home parks here. They were county unincorporated. So at the time, the owners of the parks, it was free market rent. Whoever they could get into their park at whatever they agreed upon, it wasn't regulated at all. So that's what they mean when you hear the term base year, and that's that rollback is because in 1987, it was competitive. There was no restriction on it. So if that helps you kind of get a better understanding of what that means.
So, the ordinance has a process, and those of you who have not done this, I don't want to scare you. The ordinance initially allowed an increase in CPI of 66 2/3% from base year to current year. And after it had been in effect up until about the mid-1990s, the city amended it to allow an increase in CPI of 80% of that CPI factor. So there's a two-step process, the way the ordinance works. We determine 66 2/3 from 1987 to 1996, and then from 1996 to now would be 80%. And everybody, the city's expert, staff, the park owner expert, if there's a resident expert, everybody pretty much agrees usually on what that percentage increase should be. So that's usually not a matter of dispute. And I'm gonna jump, this slide explains how we get to the increase. I'm gonna go to the slide, first, my visual aid. This is a slide that shows on the left, the base year NOI is represented by the light blue. The grayish or lighter blue is we take that base year net operating income and we increase it by, let's say the CPI went up 50%. We increase it by 50%, and the top of the line, the box is where that current profit is. Should be, sorry. We look at the right-hand box, and that one in green is what they're actually earning. So visually, they're earning more than what they should be earning. That means they're getting a fair return. So if they're earning $150,000 and based on what the formula says they should be earning $100,000, they're earning $50,000 more than what they need to have a fair return. So in this example, they would not get an increase. On the other hand, if we did a similar approach and let's say the base year adjustment calculation shows they should be earning $150,000, but when we do the current year profit calculation or the net operating income determination, they're only earning $100,000. So there's a $50,000 gap between what they should be getting and what they are getting. That $50,000 becomes the rent adjustment. You take that amount, you divide it by 12, you divide it by the spaces, and that's the rent increase. Everybody gets the same dollar amount of increase, but they may not get the same percentage increase because we don't do it by percent for each space. And this is, again, just the numerical. If you like to see the math set out, this is one way to do it. When you get a staff report, the city will have an expert who will calculate the M&OI rent adjustment. Usually there's disagreement, and I'll talk a little bit about that, between what are or are not allowable expenses. As I said, this slide is the CPI adjustment factor. There's usually not a disagreement about that. This slide, I apologize for how tiny it is. I was trying to get it all on one slide. This would show you how it actually works when we apply the percentage to the income and expenses.
Yeah, I have a quick question regarding the size of the mobile home. Would it make any difference compared with a large size and a small size?
Nope.
Okay.
The rents may be different based on size, not always. Sometimes they're different where they are in the park. There's locational changes.
And that depends on what was done in the base year, because a lot of the coaches have never moved, and they could be in a single wide space, they could be in a double wide space. But once we implemented rent control in 1991, and then we rolled the rents back, say, Mr. Chu, you lived in that park for the last 30 plus years, your rent has only been adjusted by that. It was initially that base that was approved in market, and then it only got adjusted by 66 2/3 and 80%. Where your neighbor, say Mr. Miller, came in and he was on a long-term lease for a while, and then he crossed over and became under rent control, his whole factor is different from what you pay. But at the end of the day, in this 50,000 case, it's all split amongst you all, no matter what your rent is at the time.
And if you had a chance to look at this slide, does anybody have any questions? What I was gonna say is the city's expert, he'll do out a chart where he'll compare income, whether he agrees with all the income categories that the park owner included. He'll have one with the expenses. He'll come up with a net operating income amount. He'll compare it to what the park owner did. Sometimes they agree, sometimes they don't. The residents may have, a similar process they go through and submit. And then you'll get the park owners. In this case, the example is no increase because they're earning what they should be earning. That might be, say, the city's expert. No, I don't agree with the park owner because they're getting 50,000 and they should have been getting 50,000 in this year. The park owner may say, no, I'm only getting 25,000. So this is just another example where we played with numbers so we could show you when an increase would be warranted. And basically, from my role advising you, if the park owner documents expenses, or even if there's disagreement, we do this analysis and it comes out, this park owner is entitled under the methodology to get $17. I'm gonna tell you, from my legal opinion, you should award a $17 rent increase. The ordinance doesn't allow you to split the baby in half or reduce it. We presume, as I said, that it's simply looking at profit and what was obtained in the base year as adjusted by inflation. Is that park owner where they should? And
Now, the only thing at the hearing, and I think Brandy was a part of it last time, was where Ken Barr was my MNLI expert. He will typically use the appraiser that the city hires, and a part of that overall recommendation on the staff level will be using those two team members. Now, at the hearing, if you decide, well, we want the park owner's appraiser numbers to be factored in there, we'll take a small break. We'll reanalyze how that number plugs in and ultimately what that bottom line number would be. But that's about the direction you have in terms of, you can take the experts, mix them up with their numbers, and you can make that kind of adjustment if it veers away from staff recommendation or what's been requested in the application or what's been submitted by the residents.
yeah, you might find the park owner's expert on a certain issue to be the most credible. You can tell staff, okay, as part of your consensus to reach a decision, we want to modify your recommendation to incorporate this analysis. What would that result be? And so they'll go off in the back room and come up, and we'll come back and they'll present it. But again, in this process, it's fact intensive. Depending on the issue, it has to be based on an expert analysis. Everybody has the right to comment. But again, if the numbers show, based on your conclusions, if the numbers show an increase should be granted, it should be granted. This slide is just listing examples of gross income as set out in the rules. And usually the areas where we might have disagreement are when the park owner puts in something to account for vacancies. So we may get arguments about whether vacancy rates were unreasonably high. That's generally where the issue is. Not even too many arguments at this point about gross space rents. We're all usually on the same page.
This is Alan in Salt Lake City. I have a couple of questions. Is it all right if I ask them?
Yes, definitely.
All right. How often can a park owner request a rate increase? Is it once a year, twice a year, or anything like that?
Annual adjustments are not less than once every 12 months, and 12 months from when the last special rent adjustment was approved. And then capital improvement rent adjustments depend on whether they want to do a capital improvement or whether they need to. So that's not so much limited that way.
The reason I'm asking that, because of the inflation at the current rate, will they all be coming back to, say, sooner wanting a rate increase, or they must wait to that 12 months?
If they have already obtained an MNOI adjustment or another type of special rent adjustment, they have to wait the 12 months. If they never have, then aside from the annual adjustment, they will typically apply when they decide it makes the most business sense for them. But we have not seen an influx of these types of applications just because the CPI may appear to be starting to go up. There haven't been that many of these types of increases requested over the years. I know
Right,
they get a
okay.
lot, so,
I was just wondering.
okay.
Thank you.
Please jump in if you want to ask anything else. This slide lists the types of operating expenses. This is where we usually have the most disagreement, the most discussion. Management expenses are typically, are pretty common an area sorry, I keep hitting the wrong way. Management expenses, normal repairs and maintenance, owner performed labor can be an area.
Not
What
to,
else?
just to kind of butt in right here, in terms of when Yucaipa became a city, back in the day, a lot of families who owned the parks lived in the parks. We only have a few of those families left. And so when they sold off to bigger corporations now, they have whole management teams. They own parks around the state and other areas of the country. And so what typically may have been in the base year is much different now because they have a professional crew. It's not someone within the family running, QuickBooks. So we have seen some of the increases. That change in management expense is a huge impact because back in the day it was the mom and pop, it was their living income. Now it's, a corporation. And so that's something that our experts have to factor in when they're looking at the application. And then sometimes when a park is sold to another owner, some of those original archive documents are gone. And so we have to typically then work ourselves back, backwards.
Yeah, and that's part of what adds to discussion on the operating expenses if you're dealing with information from 1987 or before, potentially. This slide just goes through more of the types of management expenses, operating expenses that are disallowed. We do not allow mortgage principal and interest or land lease expenses or other type of debt service because the whole point is to insulate rents from what can be artificial changes in the market. And so typically when we get an application, there may be disagreements about whether something is excluded by the rules or not. So there will be information in the staff report and all the various documents. So it's the park owner's responsibility to show through documentation that they're entitled to a rent adjustment under this process and in the amount that they want. And as with the capital improvement rent adjustment, they have to present substantial evidence of the base year and current year gross income, operating expenses, and NOI. Now, there is a modification of this type of adjustment that we call, you'll sometimes hear it referred to as the Vega Adjustment because it's based on a court decision. That's where the park owner says, in the base year, which is 1987, my return was too low. And it was too low because I was a family park at that time and my mother, who was the primary decision maker, wouldn't let us raise the rents because she thought everybody in the park was her friend. So the rents were artificially low. Or we had, and that is a common thing to have happen. Expenses may have been unusually high in that year for a variety of reasons. So in that situation, the park owner is entitled to show, I'm entitled to increase that base year net operating income by some amount that would really reflect what I should have been earning. And as I said, the court in this Vega decision said, yes, you have to give the park owner the opportunity to do that. And so if they can show, using the factors on this slide, Things like my operating expenses were unusually high, even though I was a prudent business person, or there were other factors listed here that I can document. You can find, or you may be strongly advised to find that they should be allowed to increase their 1987 NOI. And so here is the example on the slide where their actual NOI was 425. I apologize, it's a small screen. But they are able to show that they really should be able to increase that base year amount by $54,000 based on whatever documentation they can submit. So we credit them in a sense with a base year NOI of $479,000. And then once we've done that, then we just do the standard MNOI adjustment to see if they're entitled to an increase. And the difference is, and this has happened, where we do the standard MNOI rent adjustment and they would only get a $17 increase. But when you give them that Vega adjustment, that bump in base year NOI, they actually end up with a $59 increase. And that can happen. And depending on the facts, it may be warranted. The last type of special rent adjustment is what we call the fair return rent adjustment. And this is, again, pretty much required by court cases, where the courts have said the maintenance of net operating income process is a good approach. The courts tend to like that approach. The Vega adjustment process is something that may be appropriate in some cases. But a park owner still has the right to come in and say, I'm still not going to get a fair return, and here's why. And the courts have said, okay, you have to let them come in and show you, subject to some parameters, like you don't have to let them, and ordinances can prohibit consideration of market value. Because if you know anything about rent control, you know the whole problem why we have it is because market value is going haywire. So, or beyond what a lot of people can afford. So this part of the ordinance, when Jennifer was talking about appraisers, this is where this kind of issue can come in. So this slide is setting out the standard, the legal test, which is if a park owner can show, notwithstanding an MNOI rent adjustment and what my increase would be under that, I'm still not going to get a fair return. So I can come in and show you, based on consideration of additional factors, why I'm still entitled to a greater rent. And the factors that the ordinance lists as examples, it's not exclusive, are that rents charged in this park are not high enough based on rents in comparable parks. That's the example Jennifer was referring to. Two parks pretty much identical, but the rents in Park A are $50 a month and the rents in Park B are $250 a month. Why is that? Well, maybe it's because Park A is not getting a fair return. Maybe it's for other reasons. But if Park A wants to argue they should be charging $250 a month or they won't get a fair return, they need to show why. Other factors are looking at the capitalization rate, which is the ratio of a park's net operating income to its purchase price. So we do look at purchase price, but in a very limited context. Comparing capitalization rates of comparable parks, that has never been sought, but it is in the ordinance. Looking at the pattern of income and expenses over the past 5 years, and quality of services and amenities, and also looking at did the park owner delay coming in, and has that affected what kind of return they're claiming they're getting? So again, as with the other increases, it's the park owner's responsibility to present the evidence to support this kind of increase. And there have been park owners who've tried to show that, usually on comparable park issues, but they've raised other arguments as well, and that means you're usually going to hear from appraisers, from other types of experts on whether each position is supported or not by the evidence. One other type of increase, which we call the fair rent adjustment based on a voluntary meet and confer. This is to encourage park owners to coordinate, negotiate with residents to come up with something they're both happy with. And there's a process in the ordinance that allows them to meet with the residents and basically conduct an election where they come up with an approved amount of rent adjustment. That does not come before you. It goes to the rent administrator, and we had one not that long ago.
We've only had one,
But sometimes that may be used.
although we put this in a few years ago.
Yeah, it's been in for a while. On the temporary rent adjustment, we mentioned that if a park owner gets an increase, rent increase, as part of their application, they'll also request recovery of their costs. The things to remember about these are they're spread, the costs, if they're allowed, are spread over 5 years. They include 7% interest, and they're separately listed on the rent bill so that they're not incorporated into the rent for future rent increases. And they have to come off, if it's being charged monthly, it has to come off after 5 years. Residents who can afford it have the right to pay it in a lump sum so that they don't incur that extra 7%. And there will be testimony on the reasonableness of those expenses.
And this is
Potential.
that Galland
Yeah,
fee that we were talking about at the front of the meeting.
correct. Rent reduction, residents can come in and request a reduction in rent. There are certain requirements they're gonna have to meet. We have not yet had that kind of request. Doesn't mean there won't be. It will be more than just 5 parking spaces were eliminated. I mean, they're gonna have to show that there's a substantial cost saving, and that if the owner, if we reduce the rents, the owner will still get a fair return.
So it would be something like if they had a pool and the park completely demoed and took out the pool, something like that substantial.
Yeah. And by the way, that's not to say every time you take out a pool, they're entitled to a decrease. It's just that it's more than just, they used to maintain the trees every week. They've gone to once a month. You have to look factually at what's going on, and it probably needs expert testimony. I apologize, I'm trying to get to everything we need to touch on in this training. So just a quick discussion on training, on the hearings. You will be acting in what, as a lawyer, we call an adjudicative or quasi-judicial capacity. As I said, you're judge and jury. You make legal determinations because you decide, is something a capital improvement? If so, then you make the factual determination, how much did it cost to do it, and what's the rent amount that we're gonna charge over a 7-year period. So your decision needs to be based on the evidence, and your decision needs to be set out in a written decision. We have a process that is more specifically set out in the commission hearing rules, which you do have. It's very specific, who goes first, who goes next. If you ever have any suggestions on how to make it better, we will welcome those. But we did this so there wouldn't be arguments about what should happen, and seems to work okay. Generally, if there needs to be an adjustment, everybody agrees. And the types of evidence you may hear will be oral. People will come in and say, I've lived in this park for 50 years. It was a beautiful park in 1987, and over time, here's what I've seen. You can have a great witness like that who gives you the history of the maintenance or bad maintenance in the park. You only need one witness to have substantial evidence on an issue. Substantial doesn't mean a lot of people saying that or a lot of documents. If you find one person is extremely credible, you can rely on them as the basis of a decision on a particular issue. You'll get documents, sometimes a lot, sometimes not so much. And you'll have the ordinance and the rules. And then you'll have recommendations from me potentially. You'll get different arguments from staff or from staff's experts or from the park owner experts or the park owner. And it's your job to sort it all out. And we try to help as much as we can. As Jennifer said, and I mentioned quickly, you have to have findings. In law, we call them Strumsky Findings because Strumsky was the California Supreme Court decision where the court said, I want that map. Courts need to know how you got from A to B. And so when staff does a staff report, they will try and lay out that map. They'll tell you what the issues are. They'll tell you where the areas of dispute are. They'll tell you where the areas of consensus are, and they'll tell you what their recommendation is based on all that. Just to go through some of the legal issues that affect how hearings are conducted, as I mentioned, we have to comply with due process. Due process comes from two constitutional sources in the 14th Amendment. No state shall deprive any person of life, liberty, or property without due process of law, and that's been extended to the cities and counties and other forms of local government. Similar provision is in the California Constitution. What that means in a real sense is people in a hearing where rights are being determined, and in this case, whether I have to pay a higher rent or whether I, the park owner, am going to get to charge the rent I want, everybody's entitled to reasonable notice, reasonable opportunity to be heard before an impartial decision maker. And those three factors, that's why our ordinance has notice provisions, that's why we have the hearing process, and that's why we have you as the commission serving as that impartial decision maker. In terms of being impartial, we ask you to withhold your determination until you've heard all the evidence. You may develop a sense, from reading the staff report, this sounds fishy to me, or this sounds like it's well documented. You may go look at the park and see something that makes you question something in the application, or you may go look and say, this looks like they did what they said they did. So don't develop pre-existing views. Be open to what you're going to hear at the hearing, and you're allowed to have an opinion, but don't have bias. If you're inclined to be more supportive of one side or the other, you need to kind of set that aside and just act on as much as possible in an objective manner. An example we use of what is not allowable and is bias that will void a decision is this case called Nasha versus City of Los Angeles, where it was a planning commissioner who was opposed to a project, wrote an article for a homeowners association newsletter, which called it a threat to wildlife. and did some other things that we didn't put on the slide that showed that person really was biased against the project. So he was not going to be an impartial decision maker when the project came before him. And in that case, his vote was needed to reach a decision because of the number of people who on the commission who were able to vote. And because his vote mattered, when the decision was later challenged, the court said that decision was tainted by impermissible bias. And so they had to go back and do it again. So we just ask you to be aware of that. I know you are aware of the existence of the Fair Political Practices Commission and their regulations. There's also something we call the common law doctrine of conflicts of interest. And those are basically dealing with not so much financial conflicts, but other situations where the decision could affect your personal interests. It could affect a relationship. It could have an effect on your financial interests, but it's not something specifically regulated by the FPPC. And it all stems back to the idea that people who come before you are entitled to an impartial decision maker. So generally on these kinds of bias and impartial issues, what we say is, if you don't think you can be fair, then don't participate, abstain. Just don't participate in that decision. Please avoid statements outside the hearing stating whether you've taken a position on something or whether you like one side or the other, or you think the park is horrible, or you think it's the greatest park in the world. Those kinds of statements can affect the perception of what the court may end up saying is, we had impermissible bias here. As we indicated, if you visit the park, you shouldn't be talking to the park owner or the residents. We know that can sometimes be difficult to avoid. Please don't make any kind of commitment. If you go to the park, please disclose that on the record at the beginning of the hearing, and there's an opportunity for you to do that. Try to make your decision. Your decision should be based on what you get in the staff report, in the materials, and anything else that is presented at the hearing. You're all aware of the Brown Act, and by the way, I do have flash drives in my car of our office's most recent handbook on the Brown Act, which I'll go get before you all leave, unless they've been given those.
I don't know if it's in the book.
No, it's not. It's not the same as what I handed out.
There's a section in the book. There's a tab for Brown Act.
You have it?
Yeah,
from
we have it here.
2021?
Mm-hmm.
Okay, if anybody wants the flash drive, I've got them, so I can leave them with you. We will be updating that because the legislature always tinkers with state law, so if they've changed anything, we have to update that. So we will provide the city with updated manuals. The Brown Act is the open meeting law of the state and basically says all meetings of legislative bodies have to be open and public, and all persons, meaning everybody in the city, are allowed to attend any meeting of the legislative body except as otherwise provided by law. You are a legislative body. You're created by ordinance of the city, and you are required to comply with the Brown Act, just as the city council is, the planning commission, and so on. What is a meeting? A meeting is any time three of you physically get together and talk about the subject matter jurisdiction that you are in charge of, or where you hear, discuss, or deliberate, or take any other action relating to mobile home park rent control. And that can be even an inadvertent discussion where you go to dinner, okay? So we strongly recommend, like if you were gonna go to the park with another commissioner, you limit it to 2. That way, yeah, I mean, I would recommend not to go with another commissioner at all, but we understand things happen. Definitely not 3. There are other situations if, and unfortunately, the world we live in, if people saw the 4 of you or 5 of you sitting at a restaurant eating, they might assume that that was what was going on, that you were talking about rent control, even though you aren't. So some of these recommendations are to give you what maybe are best practices to protect you, and some because we don't want any of you to be accused of inadvertently violating the Brown Act.
In addition, monthly YMRA holds a meeting, of which I'm sure you've all been invited to that meeting. It is for the betterment and education of residents living in a park, not necessarily the park owners. They have other meetings. And so if you decide to go and there's a couple of you or 3 of you there, even though it's not a city-called meeting, that poses a pretty large problem. Not only the violation of the Brown Act, but even perception of what you're doing. So if I'm a park owner and I just decide to show up and then there's 3 mobile home rent review commissioners that are neutral, I'm gonna start to question your neutrality.
Yeah, and honestly, if that situation were to arise, we would strongly recommend one of you. It wouldn't be enough for the 3 of you to sit in different places in the room. So, and one type of meeting you need to be aware of is what's called a serial meeting. A serial meeting is where there's a direct or indirect communication employed by a majority of you, in this case it would be 3, to discuss, deliberate, or take action on something that would be or is an item of business. What that can involve, we have what are called the chain or the hub and spoke. The chain is where I talk to Commissioner Black talks to Commissioner Green talks to Commissioner Red, and they develop a consensus through that process. Even though they're not all in the same room, that chain creates a consensus. That's one area, the hub and spoke. Yes?
Quick questions. Can the commissioner attend the Mobile Home Park Association occasionally?
Well, that's if like the YMRA meetings, that would be the same kind of issue. That, I mean, because your job as a commissioner is to make a decision based on what is in front of you at the hearing, while attending a resident meeting helps you get to know the park and the people and what concerns them, that's kind of outside your scope. And so, and it also raises the issue of the Brown Act. So I would recommend you not do that. And
Go to park meetings?
yeah, I would just recommend you not do that, because you may start, if you do that, you'll start hearing things that could affect your decision on an application, and then you're getting information outside the hearing, and that's gonna create a problem.
In doing this since 2004, you get invites to YMRA, you get invites to the Met Christmas parties, you get invites to the parks, to a potluck. My advice to you, even though it seems rude, you don't go to any of it. Then you are never in question. The time I attended a YMRA meeting was to prevent information regarding our ordinance and rules. It was a factual, educational based attendance at that meeting. Other than that, if you stay out of those opportunities, the better off you are, and no one can ever call you into question.
Yeah. Oh, the hub and spoke, just quickly, where one of the commissioners talks to, Jennifer has a, I'm not saying this would happen, there's a one-to-one meeting between a commissioner, and then the staff person goes to other individual commissioners, and through the course of those individual meetings, there's a consensus. That's called the hub and spoke. That's also an unlawful serial meeting. Serial meetings are illegal, and even the best intentions can result in violating the Brown Act. Email can be a problem. Don't hit reply all. I have a little thing in my office that says nothing good ever came from hitting reply all. And it's true, because some district attorneys will say, if you get an email as a commission from somebody and you, on a rent control application, and you hit reply all, so your response goes to all four other commissioners, even though you weren't trying to communicate anything to them about whatever the issue is, some DAs say that's an illegal serial meeting. So if you get an email that is addressed to all of you, make sure when you respond, you only respond to the sender. And just
For anything.
anything, yeah. It's, I mean, email is a challenge for everybody who serves on a body like this. It was not designed to think about things like the Brown Act. Also true about texts, true about if you participate in Nextdoor or one of those other blogs. Again, if you know commissioners are on the same blog, you need to be really careful not to discuss anything relating to rent control. And if you get questions from members of the public, do not respond to those. Tweeting, same thing. Now, there are exceptions to meetings where there's not a violation. Individual briefings from staff, or if you call me, excuse me, because you have an issue, or you call staff to ask a question about something, or if the staff person sits down with you to help go over what the application is, those are not meetings. As long as nothing develops like the chain or the hub and spoke. Where you're just getting information in one direction, that's okay. Be careful when you're talking with other commissioners. Don't ask what their view is on something. Don't ask staff what another commissioner or commissioners think. And staff or I will not be conveying to you if we know somebody's called and had an issue about a particular application. We're not going to convey that to you. Attending a conference on rent control, you could do that if there were one. I mean, we would give you advice about, sometimes councils and commissions actually adjourn to the conference so that no one can accuse them of violating the Brown Act, or less than 3 of you go. That way there's never any issue. Various types of general community meetings are fine. Some of these issues have to do with the city council, so they're not really gonna affect you. But again, it's just be cognizant when you receive invitations to events, who is sponsoring it, who is gonna be there, and if you think 3 of you are gonna be there, think, do I need to maybe not go, or do I need to talk to the city staff or to the city attorney's office to find out if there's any issue? Doesn't hurt to ask. There's no stupid question. I know, because I ask a lot of them. It's better to ask than to inadvertently have a problem.
If they go up, it's like a free luncheon, the price of the luncheon, because they're Form 700.
That's the whole.
They need to know that.
Okay. If you are given offered a free lunch, that will trigger your reporting requirements under the PPC regulations, because there can be gift issues, there can be financial disqualification issues. So I would say decline any free lunch because it's not really free. If you do get a lunch paid for, you need to look at getting the value of the lunch provided to you so you can put it on your Form 700. If you haven't had a chance to look at the FPPC website yet, they have a lot of information on that. Jennifer's office is really good about answering questions. Do you have the conflict handbook also in your binder? Not that, it
No,
won't
I
be
think
in
it
there.
If not, we'll get it for you.
Yeah, we can get you that. If you want, the flash drive that I brought has that on
Yeah,
it.
it's on there.
Okay, good.
There's a
Okay,
conflicts of interest tab in our binder.
good, okay, yeah. And, okay, let's see. Just a quick note on meetings. The Brown Act is very specific about what kind of noticing has to be posted, sent out, et cetera, depending on what kind of meeting is involved. Our ordinance provides for certain noticing requirements, so you'll get the notices required by the ordinance. The agenda will be posted in advance of the meeting, just like the city council agenda is. And the agenda packet will be made available within a certain period of time prior to the meeting so that anybody can come in and take a look at it. And it will also be sent out to you ahead of the meeting, hopefully with, we try and do as much early circulation as possible because we know there's a lot of material. You are limited under the Brown Act to only discuss what's on the agenda. If the subject of the hearing is Bloomfield Park's capital improvement rent adjustment and there's nothing else on the agenda, you can't discuss anything else. If a resident comes in during public comment and raises an issue, all that the chair should do is refer it to them to the staff, and if it needs to come back for some reason, staff can bring it back on the agenda. And there are some exceptions to that rule. Generally, they don't come up in rent control. It could be like something happens after the agenda was posted that has to be decided or dealt with at the next meeting. And so there's a way to add something to the agenda. There's a process. Probably not going to come up for you. Public comment. We can't prohibit public criticism of individual members of the commission, of council members, of other city officials, other city employees. There's a privilege for statements made at public meetings. It's an exception to defamation laws. So sometimes people say things that can be nasty or cruel or inappropriate, and we ask for your, I guess, patience and recognize that happens and doesn't mean it's true, doesn't mean people will believe it. They say their piece and they get off the speaker's location and they're done and we move on. Not to say we don't have rules of decorum. We do. People can't make threats. People can't get physically violent. People can't refuse to stop speaking when their time has ended. I mean, those kinds of things we can deal with. But we recognize meetings can get heated and emotional sometimes because these are serious issues. People don't have to register to speak in a public meeting. They don't even have to give their name if they don't want to. They don't have to give their address. They don't have to live in the city. We like to get that because it helps keep track of people in terms of getting them follow-up information and so forth. We have time limits on speaking depending on what's going on. That's to make sure the meeting gets finished in one day. And we do allow, under the Brown Act, people can record, they just can't interfere with what's going on. So they could bring in their own court reporter, they could stand there holding their iPhone for the whole meeting. They can do that, but they just can't interrupt or otherwise prevent the meeting from proceeding. Closed sessions are allowed under the Brown Act. It's unlikely that we would have to go into closed session with you, but it has happened on occasion. Those are basically where there's litigation or threatened litigation, and there's a process where we would tell you what needs to be done to properly go into a closed session. Your deliberation on the adjustments is in the public. We don't go into closed session for that. So any questions that you have, you will discuss with each other. However, if you have a question that you want to ask me and you don't want to do it in the meeting, in the public portion, you can do that. Either before the meeting, you have my phone number, my email. You can let Jennifer know, or if you want to ask staff. The deliberation itself has to be in the open. There are consequences for violation. Violating the Brown Act is a misdemeanor. And also there can be civil actions taken either by the district attorney or members of the public. There's a process that, depending on what the person challenging it wants to do, they're trying to void some action and they argue it was done in violation of the Brown Act, certain things have to be done first. But we just want to make you aware it is serious. There are DAs who love going after local officials. Makes good press. Did you have a question?
Thank you, Ms. Grayson. Madam Chairman, can we take a quick 5-minute restroom break? Would that be okay?
Yes, and I'm almost done. I know I'm running over, so.
Take a 5-minute break. Nope, I'm here. I'm going to be one of the very few here today. When I get back to the office.
Our office is closing at 11:45. Do you have to
Mr. Allen, are you on the phone still?
Yes, ma'am, I'm still here. I had to
Okay.
unmute you.
We should wrap up in about 10 maybe.
Yeah, at most.
Okay, no problem. Well,
Okay.
this is quite a booklet we went through today.
Yes, we did, and I apologize, I had to rush through some of it.
Oh, that's all right. I was following you along, and you know, I closed my eyes and could visualize your PowerPoint.
Okay. All right, so the last area is the Public Records Act. Something to keep in mind, not only are the way meetings are conducted regulated, but we also have the Public Records Act, which makes basically anything that relates to official business of the city a public record, and the public has a right to inspect it and obtain a copy. Where that can come in to affect you would be where you are getting emails, say, from staff about scheduling meetings or sending out the agenda packet, or if you get inquiries from members of the public. Can be by letter, as our chair mentioned, if you get something in the mail, if you get an email from a person who lives in a park, those are all public record. And so what you need to be aware of, the definition of public record is very, very broad. It's any writing containing information relating to the conduct of the public's business, prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. It includes email, it includes texts, it includes blogs on social media, it includes Facebook postings. I say all that because in this era, literally anything that you send, if it relates to mobile home park rent control or an application, can be a public record. So, there are some exceptions, and these are just some of them. Depending on the circumstances, they may or may not come into play. If there's a draft staff report written and it's discarded later and that's not the final document, that draft is may be considered a preliminary draft, which is not retained in the ordinary course of business. It's not a public record. For your purposes, if I provide the commission with a confidential memo on a legal issue, that is not a public record. That is protected by attorney-client and work product privilege, because in this context, I will be acting as the attorney for the commission. Some documents that show how individual commissioners are evaluating issues can fall within what we call the deliberative process privilege, and that they may have some protection. So if you were sending an email back and forth to staff on an issue, or maybe more likely to me, the deliberative process privilege might come into play as well. There's also a catch-all exemption that says, even if it's not one of these listed exemptions, if we look at the facts of the particular case and the public interest served by not making the record public clearly outweighs the public interest served by disclosure, then we can withhold it. But obviously that leaves a lot of area of dispute. So we just need you to be cognizant of the fact that there are lawsuits over access to records. If a person sues to obtain a record and obtains it through a court order, then the court can order attorney's fees and costs against the entity. So just to be aware of that, and that has not happened in this context yet. We have had some public records requests in my experience, maybe not with this city, Other cities I've worked with on rent control, every now and then we get a public records request just because either the park owner or the residents like to see if there's something they don't know about. But it is something to be aware of. Like with the Brown Act and reply all, just be cognizant of the fact that emails, texts, things like that on social media can be public record. Don't put your personal business as part of an email dealing with the commission. You know, I mean, if a request is made and we have to go through and black out, we call that redacting. We will black out something personal, but nobody wants to think that their discussion about their wife's birthday gift is going to be in a record that goes to some stranger. So we just ask you to remember that. And generally, the best advice I can give you on the Public Records Act is don't use social media to discuss anything related to the commission or any application. It's the easiest way to avoid a problem. I recognize not always convenient if you're relying on email, but it is really the best way to avoid the problem. And do you have any questions for me or Jennifer?
Couple questions on the documents. Really simple questions. One question is, I don't understand, what is a snowbird space? Snowbird
Oh,
space.
I apologize. A snowbird space is one of the types of space rentals that are exempt from the ordinance because they're not occupied by the resident as their principal residence. It could be somebody who snowbird because it could be somebody who lives back east and comes out to California in the winter. But Jennifer's telling me we don't
Second
have any.
homes, the second homes like that,
Yeah.
yeah. What is the RA?
Rent administrator.
Oh, okay, that's you, okay. Also understand that the DMV also collect fee from the residents or the property of the homeowner, so the owner, property owners. How's the interface with our regulations?
The city collects a registration fee, which, what is it this year? I looked and now I have forgotten.
8 something.
It's 4 something for the resident and 4 something for
The registration fee approved by council for 2021 is $8.50, of which the net's split in half. Half is paid by the park owner, half is paid by the resident, so it's $4.25. That rent control registration fee has nothing to do with the DMV.
Okay,
It's completely separate. That's because it's a vehicle registration. It has nothing to do with the city. Our
Okay.
registration fee is about maintaining the rent control process that we have here at the city.
I see. Okay, so I have nothing to do with that at all. Okay. One clarification I'd like to ask that is, I'm also a member of the Uptown Yucaipa Association. Would it be okay? There's no conflict of interest?
There's no conflict of interest. That has nothing to do with mobile home parks.
Nothing
No.
at all, yeah. Okay. Thank you.
You're welcome.
Madam Chair, I have 3 questions that I was saving for the end. I guess this would go to Ms. Grayson or Mrs. Crawford. How often of the 43 sites has ownership changed over the past 5 to 10 years? Are they, for the most part, long-term owners? Just roughly.
That's a hard one to answer, to tell you the truth. I want to say there's probably maybe 10, just shooting from the hip, that are still the original owners, 10 to 15 max. The rest are now been purchased once or twice.
Thank you. Just kind of wanted to get a ballpark if it was long-term owners for years and years, or is there turnover at times with ownership?
It would have been more so long-term owners back when the ordinance was
Okay.
first adopted.
Excellent.
I understand hedge funds are buying mobile home parks, so.
There's very few family-owned parks at this point. There are some, though.
Okay, thank you for that. And what is your experience has been the most costly capital improvement request? You'd mentioned streets, maybe a clubhouse or something. What is the big dollar items that have been asked for before as a capital improvement?
Primarily streets. And I can also provide you with the listing of all the special rent adjustments that have come before the city and capital improvements. I'll have Kim provide that to you.
Thank you, Ms. Crawford. And does the city get to count affordable housing for state requirements of,
No, mobile home parks do not count because they're already existing. Now, if we got a new park in the community, that would. However, due to legislation, they wouldn't be controlled by rent control because they were built after 1990.
thank you, Ms. Crawford. And thank you for the presentation. Ms. Grayson was really good. Thank you, both of you guys.
Thank you. I was going to add one thing just on Jennifer's answer. The construction of the mobile home park internally, placement of mobile homes on pads, the way the streets are constructed, that's all regulated by state law. So even if a city is the enforcement agency, which some cities are, we don't have the ability to impose local standards except in very limited circumstances. So, interesting dichotomy.
I have a quick question. If a mobile home park expands, does the new expansion come under the rules, or are they exempt from the rules?
If it's constructed after January 1, 1990, by statute, it is not subject to rent control.
Okay, so half the park could be under rent control, and the new additions has no control.
Yes.
No rent control.
Yes, if you're familiar with Plantation on the Lake in Calamasa, the old section, the original section is under rent control and the newer sections are not, for that very reason.
Right.
Yeah.
Okay.
I have a
All
quick
right.
question.
Enjoyed the presentation. It was very good.
We appreciate your patience.
My question is on the reimbursement of application and hearing costs. So the tenants, they have to pay that regardless, even if the person applying is denied?
No, only if they get an increase.
Right.
Yeah.
Thank you.
Any other questions? So at this
Just wanna let you
time,
know it's-
I'm sorry.
Just want to let you know it's cold in Salt Lake. It's 36 degrees.
If the commission has no other questions, then I would move that we adjourn the meeting or the training.
I will second that.
Thank you.
Thank you.
Thank you. Enjoyed it.
Thanksgiving.
Happy Thanksgiving to everybody.